Yes, Mr. Roux.
My lady, if the court would give me an indication as to the times that the court will sit. I see it's 3 o'clock.
It's 3 o'clock.
Yeah. So we have two options, one to go a bit later, or the other one is possibly to start at 9 o'clock to
At 9 o'clock.
make sure that we don't intrude on your Sunday.
Okay.
I may say you refer to reply, and I may just refer to Section 175 of the Act. The state has no right to reply on the facts. Only with leave of the court. He can reply on law. But I may say in the same breath, we gave them all our cases and the heads before the time we should have. So I cannot see that happening.
Yes.
So sensibly it should be us tomorrow, but if the court would consider 9 o'clock, that would assist, or alternatively sitting half an hour later.
Can we sit until 4? I mean, 3:30. Let's sit. Suzette? We can sit on another half an hour.
Thank you, my lady.
Yes.
My lady, I think that before I deal with the heads of argument, just to hand to you pages, there were some problems, typing problems on pages 205 to 208. We have amended pages available with punch holes in. If you would kindly just replace that. Thank you, my lady. And then also, before I turn to our heads of argument, maybe just dealing with a number of material mistakes made by the state in its address, and maybe we should just highlight some of the difficulties. The one thing we would ask the court when the court considers our argument is, we know on the facts that Dr. and Mrs. Stipp, and to some extent Mr. Slingetwa, heard the first shots. And then the second sounds, that's also described as shots, were then heard by this Dr. and Mrs. Stipp again, and then Mrs. Berger and Mrs. Johnson. And we were waiting for the state to tell the court what were those first shots. And you will not find the answer in his heads of argument, and you will not find the answer in his argument. And one thing you cannot do in a criminal trial, you cannot ignore a serious material objective fact. You cannot do that. And the state has done it. I know why the state has done it. Because it will cause a nosedive of their case on the 317 description, what they described as shots. They also don't deal with the cricket bat striking the door because they cannot. But we'll deal with that. The second point is this, my lady, and that is the state started off by submitting to this court that he's so reckless with the firearm. Look at September and look at January, and now, of course, again in February. There are two difficulties. The one is we refer in the heads of argument to De Bruyn's matter, saying, there was previous case Kanyapa, and it overruled it, the Supreme Court of Appeal, to say you cannot take a conviction of the other counts into account for purposes of the murder in this case. You cannot do it, but we'll deal with that. So the state cannot do that. The second point is that it was to some extent called a presumption of continuance that the authors in all the books dealing with the law of evidence will work with, and warn against that. And the state also very subtly tried to apply that. How did the so-called presumption of continuous work was, you see a man or a person driving fast, and 2 kilometers further, you don't see him all the way. There's an accident, and a whole question then arose. Can you say because he was driving fast here that the speed was the cause of an accident later on? And there's a warning to say there must be a nexus between them. Unless you can have that nexus, you cannot apply that so-called presumption of continuance. And that's what the state really tries to do. He says, because of that, and because of September, and because of January, it must be February. You cannot do that in law. That's contrary to our principles. The third point is that we will also deal with where the state made a submission, say, but he was not anxious there and there in certain circumstances, but he refers to situations where the accused was not confronted with danger. An anxious person and a vulnerable person does not walk around and show his anxiety and his vulnerability all the time. That will come to the fore when there's a danger or a perceived danger. Just to correct that.
Just repeat that.
The state made a submission and also in the heads and say, but it was a good evening, there was nothing wrong, there was no reason for him to be anxious. Now, where's this anxiety now coming from? And all we say, when you consider anxiety and vulnerability, you must consider it in the context of danger or perceived danger. It won't manifest just in a normal walk of life. When a person goes to bed, he may go to bed and be happy and be smiling. It's not to say 2 hours later when you wake him up and he perceived dangers, that because he was happy and smiling 2 hours ago, he's now not an anxious person. It depends on the anxiety and on the evidence.
Yes, but was that the evidence of one of the aspects?
That was a submission made that I'm just responding.
No, I understand the submission. What you're telling me is it depends.
Yes, no, but it was the evidence.
Was the evidence.
Professor Scholes told us so. He says,
yes.
You have the 2 Oscars. Okay. Yes, it was right at that point. He explained to us the 2 different Oscars. One that you will see that's everything fine, and the other one that you won't necessarily see when he's vulnerable.
Yes.
That was the evidence. And then, on the acoustics, if I may just make this point, we will ask the court to carefully distinguish between audibility and, of course, intelligibility. And it's not the same. Once you interpret, it gets to intelligibility. The plain hearing is audibility, and we'll come back to that, and the state was not drawing that distinction when he referred to the evidence. Then the state said that we were unfair in the heads to say that or to complain that in his cross-examination that he repeatedly called the accused a liar. He said he went through the record and he could find one place. It's not so, my lady. Can I just give you a couple of page numbers? Mm-hmm. It's page 1548, 1550, 1685, 1621, 1743. I will repeat them again. 1548, 1550, 1685, 1621, and 1743, where he said to him, you are lying And I did not get to all. I just thought, let me give you a number just to answer that otherwise the impression is that we misled the court by making a submission not backed by the evidence. And then the other principle is really important, my lady, and that's the failure to call witnesses, where the state submitted and referred to the case to say that the state is not there to play chess against itself. That was the submission. It's very different in this case. It's very different. And if I may just make this submission, Van Rensburg and Van Staden did their best to create the impression that they were alone at the crucial time in the beginning. Later people came. And we exposed that by presenting affidavits in the cross-examination of police officials saying, no, that's not true. We were there and upstairs. And this is what we saw. We saw the gun in the bathroom and so on and so on and so on. So it's not just to say you don't have to call a witness. It is in situations where the state is in possession of affidavits by other policemen saying it's not true, we were there. And then what the state does is to call one policeman to say, I was the only person there at the time. Then it's very different from playing chess against yourself. Then we get back to the without fear, favour and prejudice principle and say, but you know from your docket statements that is not correct. And that's where the failure becomes important, to call those witnesses. The second part of that is also crucial. We know that Hilton Botha was the investigating officer. We also know, and I will show it to you in the bail application, that he told blatant lies to incriminate the accused. We'll point that out to you, what he was doing. And we know he was in that bedroom. And we invited the state and said, where is he? Why don't you call him? And we got up in the evidence of Colonel Van Rensburg and said, tell us how you're going to call him. And he says, well, I don't know. I haven't made up my mind as yet. So it's not just a matter of not calling a witness because you're not playing chess against yourself. It's a crucial witness in that principle that's not before court. The third aspect is you cannot dump, for lack of a better word, a police official on the defense and say, you call him now, and then wait and see how accommodating he would be when the state cross-examines him. Now he concedes everything. That's not what a criminal trial is all about. But to show to you, may I demonstrate to you the seriousness of this aspect. It's in the fourth point where the state says the defense relies on this conspiracy. Who would take the fan and move it? Who would take the duvet and put it down there? Where's this conspiracy? It was never put. My lady, may we make it clear? We're not talking about a conspiracy. We're talking about difficulties that you would expect items to be at place A and it's not. And can I take you just through one? And that is this. It was common cause. And I can give you the page numbers, but one I want to give you, it's page 1684, I repeat, 1684 lines 16 to 25. And it was repeatedly put to the accused, and the accused accepted it. With that silver fan, that tripod fan, standing in front of the tripod, standing in front of the sliding door, you cannot get onto the balcony. So you lie if you say you ran out onto the balcony to shout, to help, because you cannot, it blocked your way. That was the evidence, and the accused said, I agree it's in my place there, but that's not where it was. Now this is the evidence. Now let us consider in that context a not smaller Colonel Van Rensburg. His evidence, I'll give you the page because we'll get back to that. That's page 834. He says, with his first walk through, he was in the bathroom, then he walked through the bedroom, and then he walked through the sliding door onto the stoop or balcony. He used both words, the stoop or the balcony. And he says in re-examination, I don't know if the fan was on or off. Now, my lady, that's the point we're making. If that fan was there early that morning when Colonel van Rensburg was there, how did he walk through that door? And how did he not, A, the fan was blocking, that's the state's own case, conceded by the defense, and B, if that fan was on, so much the more if the fan was there, he would have known it. He doesn't know about it. So it shows inadvertently things could have moved. The police come in, the fan is right between the radio and the bed. It's in their way. They didn't think at that time something would turn on a fan. Why would they have thought that? Move it away. I can understand it. I can understand it, and that's all the accused was saying. It's not there, and if we think it did not happen, let me remind you of 2 incidents. Warrant Officer van Staden tells us, I picked up the carpet. He referred to this as the mat. I picked up a carpet, and there I saw the white telephone. Before the photos. He did that, so they picked up things. We know it. We know things like that happened. So, and that's the difficulty that we have in the case. And we say what the state does now, to say, you come with this conspiracy theory. You come with that. Show us, why would the police move the fans? My question is, how would they have moved through there? It was in their way. And if the fan was in the door, in the sliding door, how did Mr. Van Rensburg, Colonel Van Rensburg, get out? It shows there's a problem. And I accept I'm not screaming at the top of my voice, conspiracy, conspiracy. I'm saying they would not have known at that time that there was significance in that. But it was disturbed. And now to blame the accused and to say to him, but you must now be rejected. You're a liar through and through because the fan is not there. Let me take you to another one that we dealt with, and maybe it's the appropriate time, my lady. The extension court. It was put to the accused on a number of occasions. Look where the extension court is. Now get back to that's photo 55. It cannot reach. If it was there, it cannot reach. So if you tell us, and you tell the court that your fan was plugged in there and you moved it to where the duvet is now, it cannot reach. That caused us, my lady, to say, hang on. Please give us that extension cord to see if it could not reach, to see if it could not extend. We received in the last moment an affidavit by Constable Leroux saying, well, I used that extension cord and I put it somewhere in the room, and we complained. We say, well, there's a video, we don't see it. But that's all resolved, my lady. That is all resolved because we asked the state, please show us a photo, if you have, how it was plugged into that extension cord. Please show us that. And he did. We got it yesterday. And we're going to show you a photo, but what that photo shows you is that the extension cord is now longer. It's now at the foot end of the bed. It can reach. And the state must have known it because it's a photo in the possession of the state, and that's our concern. How do you put to an accused that you must lie because it cannot reach? If that's its position, it cannot reach. It cannot. When you have at the same time a photo showing that it in fact moved further on, it reached. We'll show you that photo. We need to connect it, but it comes from the state. The last problem there, Colonel van Rensburg tells us, I did not touch anything. I say, please repeat, make sure that you understand. Did you touch anything? No, I was just walking around. Then we show him a photo, that's Exhibit 00, that we will show you again and make it quite clear. And there he's sitting with his hand on the plug of the, on the clipper. He sits with his hand on the plug. I can't say if it's plugging it in or plugging it out. What I can say, it's contrary to his evidence that he didn't touch a thing. His answer to that is not, I test the clipper. He said, I was testing the linkage to the fan. It's not true. We'll show you the photo. His hand's on a different plug. So now the state tells us, or tells the accused, you're a liar. You're a big liar. There is no space for that plug. What he doesn't tell us is that we don't know what the position was with the multi-plug at the time. We don't know when that happened because we can't find the time on the photo. We see that the curtain is different than before. So those are the difficulties. We're not saying conspiracy. We say the scene was disturbed, and what you cannot do, my lady, is then make the accused a liar because of the disturbance of the scene by the police. That is the difficulty. But everything I've submitted this far, my lady, will show photo and the parts in the evidence to support what we're saying. The second part, if I may today, my lady, is this. In trying to understand the state's case, and we made that statement to say it's self-destructive. Because on the one hand, we made that statement, but I'm going to illustrate a number of submissions today to support that again. Where the state would on the one hand say, but Mrs. van der Merwe heard the argument, the woman talking, the female talking, and then the shots. And then we hear, on the other hand, the screaming, the terrified, blood-curdling screaming, and then the shots. They're not the same. They're not the same. It can't be the same shots. Because if there was the blood-curdling screaming before the shots, then Mrs. van der Merwe would have told us that. May I just correct one thing whilst we deal with that, and you referred to that, my lady. At one place in the record, and I will show you, you said Mrs. van der Merwe was maybe in and out of sleep. The difficulty came in with this. If you would just make a note of that. And that is in page 159, if I may ask you just to consider this. Where the word is used by the interpreter, she woke up. Correctly, it tells you she was sleeping. She woke up. But that's wrong. We've got, remember, we also made available, my lady, the other transcribers, where you have the Afrikaans. That would be on 225. She was meaning to say, I got up, not I woke up. Ek het opgestaan, I got up. So she was not sleeping. She was trying to sleep. She says that, even by putting the pillow on her head. But she says, I got up in Afrikaans, and it was translated as, I woke up. If I may just deal with the corrections, the state submitted that on count 3, and you would have seen the heads, my lady, I'm not crossing big swords on count 3. I'll say it now, and I say it in the heads, the accused was negligent in the way he handled that firearm. And we'll come to that. So there's no running away from blame there. But what I say, because it's important how he was negligent, is a state submission, that it was never his version or anyone's version, that what happened, how did the gun go off? My lady, it is. It's a state witness's version, and you will find that when we get there to the heads of argument, on page 13, dealing with the count 3, where Mr. Lerena said, I do remember Oscar very clearly saying, apologizing, is everybody okay? Is everybody okay? I apologize. I do not know what happened, how the gun went off. It was a mistake. I'm not saying that we're going to try and run away from blame there, but I say insofar as the statement was made to you, the submission, that there was no such evidence, that's not correct. That was the evidence of Lerena. On the count 4, also not dealing with count 4 in its entirety, just this. The state submits to you that there's strict liability for possession. My lady, there are so many cases on our constitutional approach. You do not have strict liability anymore. It is interpreted with culpability, and in the case of the firearm, you don't need intent. Negligence is good enough, of course. But what you cannot say when you go to the possession element. We've referred to cases. That's the case law. It's saying possession consists of two legs, detentio and animus. And we dealt with this. And ultimately, it's for the court to decide on the facts of the case. And it's going to be a difficult decision because it's a legal decision, where he says, I had detentio, but not the animus, because my father put it there. It's his ammunition. I can't even use it. And then, as a matter of interest, my lady, the Firearms Act, the applicable act, contains no provision that you must place a firearm in your own safe. It talks about a safe. Never, ever, it must be in your own safe. But we'll get to that. My lady, then, when I said I was dealing with what I call self-destruction, I dealt with how can you on the one hand say that there were shots after an argument, and in the next moment you say there were shots after terrified screaming. They're not the same time. Both can't be the shots. But the state goes further on other aspects as well, my lady. It says now in the heads, they were downstairs, eating downstairs, 1 o'clock in the morning. And then they had an argument. And then Ms. van der Merwe would have heard. Now, I don't know on what evidence the acoustic situation would have been better there than upstairs. Let's forget about the fact that there's no such evidence. But let's work with the problem in that statement. If that is the state's case now, that they were sitting downstairs, eating, 1 o'clock in the morning, and arguing, what must I make with the statements in the trial that she hurriedly got rid of her jeans? That's why they were so crumpled, in trying to get away from him. Does it mean now it doesn't fit in, my lady. It can't be both. He says that in his submissions that she was standing in front of the door. She did not know that she was going to be shot. They were talking. That's why she was not hiding. That's his submission. Then I say to myself, what must I now do with this blood-curdling, petrifying screams? How does that fit into them talking? Where that screaming started from 3:12 to 3:17, according to the witnesses' notes of Mr. Johnson. It cannot be the same. You cannot stand there talking, and she's not scared because she did not know that she was going to shot, and stand there in front of the door, as opposed to the petrifying screaming. Both can't reconcile. The state also says that the duvet was thrown on the floor in a desperate attempt of the deceased to run away, to flee. That was one of the statements. But now, if they're downstairs, eating downstairs, and there's now the argument, how does it now get to the deceased jumping on the bed and throwing the duvet off? It doesn't correlate, my lady. So, and all these difficulties appear in the state's case because they are forced to vacillate. And that vacillation started, my lady, when the state realized in Dr. Stipp's evidence that after the shots, the deceased could not scream. It was after that, for the first time in this case, that the state, Mr. Nel, stood up and said, let me put it on record. We say that the shots were the second cells, the 317. It had to do so. He had to do so. And there's a simple reason for that. Because he realized all the evidence of a female screaming would be impossible after the first shots. So he had to move the shots from the first shots, Van der Merwe heard it, the 4 shots, to the cricket bat sounds, the 3. He had to move it. Otherwise, all his witnesses were discredited. The difficulty, of course, remained. What would he now say about the first shots heard by Van der Merwe, the 4 shots? What would he say about it? What would he say about the first shots heard by Dr. Stipp and Mrs. Stipp? And what would he say, when did the cricket bat happen? He can't. And it's the state that's presenting the case. It's the state that has the onus. We understand, we know the cases, there's no duty upon the state to close every avenue of escape and fanciful possibilities must be ignored. That's not what this case is about. It's an avoiding of material, objective facts that's causing the difficulty. And then we must look at Blom's case. And Blom's case is still from 1939, the law. And it says, if your case is based on circumstantial evidence, which is the state's case, then you need 2 things. 1, you must show that the proven facts only justify one inference and that it excludes all other reasonable inferences. We're not talking about fanciful inferences. All other reasonable inferences. It must exclude that it was not an argument. It must exclude the first shots. It must ignore it on the state's case. It was not there. We must forget about the cricket bat noises because the state could not talk about it. What did he say about it? When was that? What did he say on the objective evidence to you? It was 3:17. We all agree the second sounds. We say it was a cricket bat, just after 3:17. We know the first call was made at 3:19. The second call at 3:20. The third call at 3:21. The fourth call at 3:22. We know then Johan Stander, Carice Viljoen, and Mr. Baba were there. They saw him coming down to 3:22. We know that because we could measure it against objective evidence. When would the accused have been able, if the 3:17s were the shots, when would he have been able to do all the things he had done? It cannot fit into that time frame. It's impossible. But the state ignores it. The easier way to say, don't look at minute contradictions. They were good witnesses. And Mr. Nhlengethwa, was he a good witness, my lady? He was brilliant. And Mrs. Nhlengethwa, was she a good witness? Did he say she was not? She was brilliant. Don't know the accused. What about Mrs. Mochwane? Brilliant. And we will show to you tomorrow that crying out loud in their description happened exactly the same time as the screaming heard by the other 4 witnesses. Exactly the same time. We will pinpoint to you the times when it happened, and there could not have been other screaming. So what did the state submit to you? The state having to prove, having to exclude other reasonable possibilities. Why did they not talk to you about the evidence of the immediate neighbors? Why did they not say, but they said, actually, it's not right. It's not a female screaming. It's a male in a high-pitched voice. And they imitated that in court, 2 of the witnesses. Where is that in the heads? The state cannot deal with that. It's unable to deal with that. And again, is unable to deal with material, objective evidence simply because he chose to move the shots from the first shots to the second sounds, because he knew that the second sounds would destroy his witnesses. And that's a difficulty in this case. And that's why we hope tomorrow, my lady, to take you through the evidence. I promise not to read the heads out. I will do a principal approach, but take you specifically to the timeline to show to you what we did with the timeline, if I may say. We ignored say-sos. We only accepted the say-so of a witness when it was corroborated by objective evidence. So we took the telephone data, all the objective evidence, and put that together, and then measured the evidence against that. And when the evidence was consistent with that, we accepted it. So the timeline we drew on objective facts, or oral evidence supported by objective facts. So it's not that we choose the timeline. It's there, and what's important about that, my lady, you will see a witness there. I've seen it many times in my life. He's quite impressive. I sort of like him, and I think he's credible. And then I go and sit in the quiet of my room, and I read his evidence, and I start to weigh it against objective facts, and I say to myself, what's going on here? And that's why we have tests in law. May I give you, it's the last point that I make, a small example about Dr. Stipp. He tells us about the accused shouting, help, 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 at a time when no one else had heard it. And we will show to you, because we have his telephone data, when he said he made calls, that that was after 3:30. To give you an example, and he appeared to be quite impressive, Dr. Stipp. Help, 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 after 3:30. My lady, at 3:30, he was a long time at the house of the accused. He admits that when Johan Stipp phoned 911 at 3:27, he was there. He'd already examined the deceased. He'd already phoned Wilgers Hospital, standing next to Johan Stipp, and then, and then Johan Stipp phoned, Wilgers said, no, you must phone 911. And Johan Stipp at 3:27 phoned 911. Then we know, he was at least 7 minutes there. We don't think that because Peter Barber told us that he went to his house and Dr. Stipp then followed shortly thereafter. And Peter Barber arrived at the house at 3:22 when he phoned the accused. He was outside and he saw him coming down. So we know it. So all we say is once you measure the evidence against objective facts, you realize that there's a difference between reliability and credibility. We don't always say a witness is not credible. Many times that witness genuinely believes what he or she is saying. That's not the test. Is that what he or she is saying? Is that reliable? And there's one way to find it out. Measure it against objective evidence, and that's the exercise we've done in the heads. And that's what we do in the timeline. And once we've put that before you, we say that it will open up, and then we can deal with the legal principles to see where the accused conduct should fit in terms of the law. What defense can you look at and what can you not look at? Would it be appropriate to stand down till tomorrow, my lady? May I inquire, my lady, will it be 9:30, the normal time then?
It's 9:30 tomorrow morning. The court will adjourn.
Gerrie Nel,